If you want to win asylum in the United States and you have more than one citizenship, then you need to see this video. I'm going to explain to you why the conventional understanding, which says that you can't win asylum with dual citizenship, has been called into question. What I'm going to share with you is going to give you cause for hope if you've got more than one citizenship and you want to get asylum in the United States. I'm Brian Manning, and I used to be an asylum officer with the government, but now as an asylum lawyer, I help immigrants all over the country secure their future in America through asylum. U.S. Citizenship and Immigration Services, known by its acronym USCIS, and the immigration courts have long had a pretty firm position when it comes to asylum cases of people with dual citizenship. You have to show that you're eligible for asylum with regard to both countries, they've said. What does that mean? Well, let's say someone is a citizen of both Venezuela and Spain. They have to prove that they meet all the asylum requirements, not just for one of those countries in order to get asylum in the United States, but rather with regard to both countries. It's like you have to win two separate asylum cases in order to get asylum. One with regard to Spain and the other for Venezuela. And this is, as you can imagine, problematic. Most people with dual citizenship who want asylum have really only had problems in one of the countries of which they're a citizen. Many people in this position haven't even ever set foot in one of the countries and just got its citizenship through their parents or grandparents. They might not have any other ties to the country, and they might not have a good reason to fear being persecuted there. It doesn't help that many dual citizens have citizenship from a country in Europe, from which it would be really hard for anyone to win asylum. I mean, sure, you've had big problems in Venezuela and there's an ongoing threat to you there, but can we really say the same about Spain? So that's the problem. A person with a solid asylum claim with regard to one country still won't win asylum if they've got citizenship for another country unless they show they meet all the requirements for asylum for that country too. And so many dual citizens have decided not to apply for asylum at all because they've heard that they can't win it because of their unique citizenship situation. To be clear, the authority that USCIS asylum offices are bound by, called the Board of Immigration Appeals, which is known as the BIA for its initials, has explicitly said that you do have to demonstrate that you qualify for asylum with regard to every country of which you are a citizen. But thankfully, that's not the end of the story. You see, not long ago, a federal court of appeals in New York shook things up by saying, well, actually, we see this differently. We think the asylum law should be interpreted to mean that you only need to qualify with regard to any country of your nationality. Like, you only have to show eligibility for one country of which you're a citizen in order to get asylum. They read the asylum definition in the law, which is, to be sure, kind of poorly written and confusing, and just came to a different conclusion than the BIA had on this question. So, does this change things? Whose interpretation governs? To win asylum as a dual citizen, do you need to prove your eligibility with regard to just one country of citizenship or all countries of which you're a citizen? Well, because of the way our legal system is structured, the answer is it depends on where you live. It's kind of messed up that the interpretation of our asylum law varies from one place to another, but that's how it is. You see, USCIS and the immigration courts must normally apply the law as it's understood by the BIA. And that's what most asylum officers and immigration judges do. They say that you have to show eligibility with regard to all countries of citizenship. But there's a twist. If a federal court of appeals has taken a different approach with regard to an issue, then USCIS and the immigration courts have to follow that approach for cases that are handled within that federal court's jurisdiction. What does that mean? Well, in this case, it's a federal appeals court in New York that has disagreed with the BIA on this point. So now, all the USCIS offices and immigration courts in areas covered by the federal court have to apply the interpretation that says you only need to show asylum eligibility with regard to one country of which you're a citizen. By the way, if you want to maximize your chances for asylum success, then be sure to hit the subscribe button and the bell notification so that you don't miss the insights that I share on this channel. All right, I said that this more favorable interpretation will be applied in places where the New York Federal Court of Appeals, which is called the Second Circuit Court of Appeals, has jurisdiction. So which regions are we talking about? Well, it's the states of New York, Vermont, and Connecticut. The Second Circuit Court of Appeals, the federal appellate court in New York that made this important decision covers those 3 states. So the New York Asylum Office, which is in the state of New York, has to apply this rule. The one saying that you just need to show eligibility with regard to any single country of which you're a citizen. Same for the immigration courts in New York, as well as those in Vermont and Connecticut. So if you have your asylum case heard in one of those 3 states, you're in luck. You should only have to meet the requirements for one country of which you're a citizen. But what about the rest of the country, the other 47 states and the US territories? Well, I'm afraid that for at least now, they're out of luck. They're probably going to lose at the asylum office, in immigration court, and before the BIA. But here's the thing to remember. There's one more appeal available after a negative decision from the BIA. And this is where the federal appellate courts come into play. That's where you're going to appeal the BIA's decision. And it's there at the federal appellate court that you might have a shot to win. You see, the other federal appeals courts have not yet squarely addressed this question that we've been talking about today. None of them has taken a position on it. So you will have the opportunity to try to convince them that they should side with you and adopt the stance taken by the Second Circuit Court of Appeals in New York, that it's any country of citizenship and not all countries of citizenship. But I've got to tell you, if you haven't yet filed for asylum, or if you have but you're waiting for an asylum interview or your immigration court hearing, well, you've got a long road ahead of you. Again, outside of New York, Vermont, and Connecticut, if you've got dual citizenship, you're unlikely to win asylum from USCIS, the immigration courts, or the BIA. And traveling that path until you're finally able to appeal to a federal appeals court where you might have a chance for success is going to take a long time. It will almost certainly take years. So you're in for a long ride, but at least now you know that there are at least might be some light at the end of the tunnel in the form of a possible favorable decision from a federal court of appeals. If you're ready to take the next step and get individualized help with your asylum case, then call my office today. That number is 713-352-1593. And remember, we help people all over the country, so it doesn't matter where you live. Call us now to schedule an asylum strategy session so that we can help you secure your future in America through asylum. Again, I'm Brian Manning, and it's an honor to serve you in your asylum journey.